Judgment in the appeal of Manchester City Council against Pinnock.
Lord Neuberger will give the judgment of the court.
This decision applies to all cases where a local authority or other public authority is seeking to evict a person from his or her home. In any such case, even where there is no other defence, the occupier will now have the right to ask the court to consider whether it is necessary in a democratic society to make an eviction order before deciding what order to make. This represents a change in English law and arises from a clear and constant line of decisions of the Strasbourg Court based on Article 8 of the European Convention on Human Rights. This decision will not affect the rights of many local authority tenants, most of whom are secure tenants, who normally cannot be evicted without a judge considering whether it is reasonable to evict them, which would in practice take into account Article 8 rights. However, where the occupier has no such protection, so the local authority could previously have got an eviction order, effectively as a matter of course, the occupier can now invoke Article 8, and if he or she does so successfully, the court may decide to give the occupier more time to go, or it may conclude that the occupier need not vacate until a certain event happens, or at least in theory, indefinitely. However, while a residential occupier has the right to raise an Article 8 argument, the court should scrutinise the argument critically when it is first raised, and dismiss it out of hand if satisfied that there is nothing in it. The court should only delay the hearing of the eviction claim to deal with an Article 8 issue if satisfied that there could be something in it. We suggest that Article 8 would be more likely to have weight where the occupiers are vulnerable as a result of mental illness, physical or learning disability, poor health or frailty, and that in such cases the local authority may have to explain why they are not securing alternative accommodation. In the particular case before us, Mr. Pinnock had a secure tenancy from Manchester City Council since the late 1970s. In light of the persistent criminal and annoying behaviour of his children, the council applied to evict him, but a judge held that it was reasonable to deprive him of his security for a year and that he could remain as a secure tenant, but only under a demoted tenancy, which meant that he had no security. His sons then committed further acts of criminal or annoying behaviour, and the council decided to apply to the court to evict him, which it did, after going through a procedure which Mr. Pinnock was entitled to challenge. In such a case, Section 143D2 of the Housing Act 1996 says that the court must make an order for possession unless it thinks that the procedure, I omit words, has not been followed. We have held that this provision does not preclude the court from considering the Article 8 arguments and resolving any relevant disputes of fact. Mr. Pinnock was not given the opportunity to raise an Article 8 argument in the Manchester County Court or in the Court of Appeal, who therefore made an order evicting him. We have held that he should have been given that opportunity to raise the Article 8 argument. However, we have held that this is a case where such an argument is hopeless, even allowing for the long time that Mr. Pinnock and his partner have lived in the property, and the fact that no complaint is made of the behaviour of Mr. Pinnock or his partner, as opposed to his children. In the circumstances, therefore, the appeal is dismissed, and the appellant and respondents have agreed a procedure which we include in the order as to costs, as to the submissions to be made as to costs. We do, however, order at this stage a detailed assessment of the appellant's publicly funded costs.